In this episode, the boys welcome former District Court of New South Wales Judge Stephen Walmsley SC, or who Awais ambitiously likes to simply call Stephen. They cover the things Stephen hated from barristers when he was a judge, what went through his mind when sentencing offenders, and what it was like to have Awais appear before him in a jury trial in Burke, with 10 witnesses placing his client at the scene of the crime.
Welcome to Elephant in the Courtroom. My name's Nick Hogan and I'm a barrister practising at the New South Wales Bar in Sydney. Sitting over here next to me is Awais Ahmad, also known as Vussi, affectionately by me. He does likewise. We're a couple of barristers who like talking about what goes on behind the routine facade of the legal machine. And so we'd like to share a few hidden little gems going on in the courtroom with you and obtain and with some first-hand insights from those who play a role in it. We'll cover topical things, experiences, things we think you might find interesting. Sometimes we'll go deep. Other times we'll keep it nice and light. So come join us as we overshare a little, doing our best not to undermine your confidence in the rule of law. Vussi, how are you, mate?
Yeah, very well, mate. Thanks
here at the Wesley again?
Yeah, here at the Wesley Mission Conference Centres. Thanks for that beautiful intro. Just as I like to remind us, we're a couple of elephants talking about elephants in the room. Well, you know, I think it's it might be apparent. But no, we're very lucky to be here. We've got a great production team and very happy to get started and get cracking.
So, Vussi, you've had a new Ahmad come into the world.
I have a 12-day-old. It just feels like 12 years.
Yeah, that'll happen very quickly because I've got a 12-year-old, and it seems like I had a 12-day-old. I
am lacking sleep, a little bit delirious, but I think I'm more of a support act than anything else.
Will you be recommending she becomes a barrister, Vussi? Do you think?
Look, I just find that I have this like preordained view that she's going to be this warrior and warrior of justice in whatever she does, but I'm sure every parent...
Assuming, well, she's got your wife's good looks and your brains. If she has,
I hope she takes something.
You know,
she'll be. You know, you have these views for your child to be probably something fantastic, but I just want her to be happy and safe at the moment. They're the fundamental priorities, and maybe even she could just sleep a little bit longer. That'd be fantastic.
Yeah, well, that's what happens in the beginning, doesn't it?
Yeah.
So, mate. We've got a fantastic guest today.
Yeah, we do.
Former Judge Stephen Walmsley.
He's actually written a book.
He has indeed. A book about the trials of Justice Murphy.
Looking forward to asking him about that a little bit as well.
Yeah, there's a lot to cover there, but I think, save for saying this, I mean, I think the viewers could do with a brief background of the Murphy trials.
Who is Lionel Murphy?
Lionel Murphy was a High Court judge. He's passed away, but in the 1970s and 80s, he was a sitting High Court judge. He was an interesting man and somewhat enigmatic man, should I say, who was accused of and charged with. He was charged with 2 counts of attempting to pervert the course of justice.
Probably the worst thing a judge could be charged with.
Well, a judge, barrister, anyone in the law, but it's anything to do with honesty is obviously about as bad as it gets. And particularly, and this is a High Court judge we're talking about.
And so whose justice did he pervert?
Whose justice? He had a friend, a colleague, Morgan Ryan, who was a solicitor, and Morgan Ryan was charged with certain offences that involved honesty themselves, forgery and the like. He was to be committed and tried, and he at his committal hearing, there was a particular judge who was a magistrate who was going to hear the committal. At some point prior to the committal, Justice Murphy is alleged to have had a conversation with the chief judge, not the judge the magistrate hearing the committal, but the chief magistrate, Clary Breeze, and he spoke to Clary Breeze and allegedly uttered the infamous words, "What about my little mate?"
Right.
To say, apparently implying that you've got to give him a hand with this charge and go easy on him. So the committal occurred, and Morgan Ryan was committed for trial, and the judge that was to hear those charges in front of a jury, of course, was Judge Paul Flannery. And
who's Stephen Walmsley, as we affectionately call him?
Stephen's father-in-law.
Yep.
And late father-in-law, I believe.
Yep.
And so Judge Flannery was then what, in his own words, described by, nobbled by Justice Murphy, and that is he was courted in a sense.
So who was the complainant? Was Paul Flannery the complainant, or did the magistrate?
Well, no. The charges were brought obviously by the state.
But in terms of who reported the
Paul Flannery did
the suggested nobbling.
He did himself, but it was only after Breeze had come out, and it was a second charge,
right.
And so we'll hear more about that. But it's
because he got tried and convicted, and
it was overturned on appeal.
Right.
This is Justice Murphy, retried and ultimately acquitted. And then not long after he was acquitted, he passed away of, I believe, cancer.
Right. Well,
but all the while continued to be a judge of the High Court. Bussy, but there's there's other really interesting, more contemporary things going on at the moment. The obvious one is the Lerman Higgins.
I am
trial.
Glued to that.
Yeah. So what have you found most interesting about it?
I just, it brings to mind like so many questions about a person's motivation in the modern world for bringing forward a defamation claim. I mean, for those that aren't familiar with what effectively you need to do in a defamation claim, and I'm by no means a defamation lawyer, so please write in and tell me
other things.
Write in and tell me how wrong I am in this. But the effect of the case is to put forward a case that someone has published that someone has undertaken a publication that's given a defamatory imputation about you. And that has then injured you, that allows you to get compensation.
And what the imputation might be is a thing that would occupy hours of arguments, by the way, in and of itself.
Exactly.
But here the imputation's pretty obvious and straightforward, isn't it?
Well, the imputation that he sexually assaulted Brittany Higgins. But the most interesting part of the defamation process is that, unlike a criminal trial where those allegations need to be proven by the prosecution beyond a reasonable doubt, in the publisher's defence, they can raise the allegations as being grounded in the defence of truth. That is, on the balance of probabilities that you did in fact sexually assault Brittany Higgins.
But they only have to prove it
on the balance of probabilities.
Much lesser, easier standard to satisfy.
And I just think when you are bringing such a claim, you have to know that you have to give evidence, and you will be cross-examined on a narrative that has a few questions in my mind.
On any manner of things, though, about your personal life and all sorts of things. And I imagine Mr. Lerman went in eyes open. He seems a fairly sophisticated sort of litigant, but there's been a lot of things.
But it's in the modern world, it's playing out in so many different examples. We obviously have the Johnny Depp trial. We have that decorated soldier,
Ben Robert Smith.
Who brought a defamatory action, and they're all kind of backfiring.
I mean, what an extraordinary, the Robert Smith trial, to prove the truth of those allegations.
Awful.
They had to bring to access all the witnesses from the war zone.
And you're taking on very heavily resourced networks.
Well, this is right. I mean, the thing that I find interesting about the Higgins trial, and this isn't brand new by any means in other jurisdictions or even really here, is the televising of the evidence or the case per se. And it's a lot different. I mean, and this to me goes to the administration of justice to some extent. I mean, obviously courtrooms in New South Wales, unless they are closed by order of the court, they are open to the public.
That's right.
And you're limited by the amount of seats, obviously, in the courtroom. And that was the thing. Apparently, the courtroom, obviously, in the Murphy trials was full every day. Yep. Like with barristers, anyone who could get in there, because it was a massive, massive deal at the time. When Stephen can talk to that. But here, you've got someone, and this goes to it, an application was made by an eminent barrister involved in the case, Dominic Hogan, which we were watching earlier.
This morning, yeah.
Is it if a witness giving evidence in a case like this, it's already nerve-wracking enough and difficult enough for a barrister and for lawyers to be in a courtroom in a trial. It's a nerve-wracking thing.
Barristers would be terrible witnesses.
But just to be in the courtroom and be there, it's already nerve-wracking enough for us. For lay persons, such as witnesses, giving evidence in a trial isn't, I imagine, I've never done it, but I imagine an enormously difficult thing emotionally. So add to that, oh no, but there's 25,000 people watching you online now on your evidence. And as you go through, the social media channel is just going nuts. And there's all sorts of comments about things you're saying, about whether they think you're true. That to me starts to impinge on the administration of justice, because the witness, I'm just not. And what does it do? I mean, look, take whatever side you like about the Me Too movement, but what does it do to wanting to have women come forward and make? I bet I cast no judgment on the what's happened in the Lemon Higgins trial. I don't know. It'll be what it'll be. Sure. There's never going to be a criminal trial by the looks of it. So that's that. But it's just it puts pressure on, and I just think it's a genuine thing, and I'm just not sure about it. I'm not sure whether it's a good idea or not.
Well, there's just a balance between public interest, creating barriers to accessing justice like the ones you identified, all the way to the pressure or the reliability of evidence once you've got 30 or 25,000 people capable of watching it live.
Oh, in that moment. And then the other hundreds of thousands who are going to watch it either tomorrow or
but is this this must be a more recent phenomenon. I mean, it is a more recent phenomenon in Australia. We've seen this happen in America for some time. I recall being 10 or 12 and waking up at 4 a.m. in the morning to watch O.J. Simpson's acquittal. And there was a jury, it was live streamed, it was televised, it became a show, and that's been going on. That was about 30 years ago.
Was it if the glove don't fit, you must acquit?
Yeah. And
what a
brilliant line that was. And that's become like culture now.
No, it has. That line is just etched. I assume that's correct if the glove don't fit, because it was a big risk and they didn't, and they put out the glove and it was just.
You just need to watch the 35,of realty TV shows that have come
I've
after
never watched them,
so
I'm proud to say that I haven't watched them. But
they are great. And the attorney that decided to pull that line, I got to say I have used it a couple of times in court with my clients who've asked me to.
You haven't used it in open court.
No. What happens is I've had clients say to me, ask them this, ask them this, and I said, look, this is our O.J. Simpson moment.
Yeah.
If we ask this, we are doing well. If we ask this and it goes the wrong way, the case is finished.
Yeah.
And so at times I've had to been pushed into a corner.
You put it as the O.J. Simpson moment.
So but just going back to that, like I think people are finding, but see, that was a criminal trial, televised. I'm not sure I've seen yet in Australia, have we, a televised criminal trial, and that must be to do with keeping the integrity of the jury. But there are other classic trials that are worth watching that I still go back to watch online. For example, Oscar Pistorius, Jerry Nell, as counsellor from South Africa, does the most ruthless cross-examination of Oscar Pistorius. He's got one knee on his chair, his hand on the lectern, and he's just pointing at him, identifying how implausible it is. And every now and then I watch it just for a bit of inspiration for my little.
But we all know that the reality of cross-examination. We'll speak to Stephen about that, because he'll be a good arbiter, or he'll got an excellent comment on what he considers effective cross-examination. But look, as far as I'm concerned, those sort of television style antics in cross-examination are actually not very effective with judges.
Yeah.
The more subtle, the better, and a lot of judges consider it that way.
And I think that's been played out in the Lerman trial, because what I'm seeing in the Lerman trial is this very monotonous, slow, crushing.
But Wybrow's been quite effective.
Yeah.
The inconsistencies and finding out. And friends of mine have been saying that it's sort of, and here's a positive to the whole televising angle, of which, I obviously pointed out what I think is the extreme negative, but is that the public engage and start to see what the process involves, and cross-examination, and it is fascinating, and I think it's important for people to understand. It's not like TV.
Yep.
It really is. There's a particular methodology and a skill to it.
Is Australian jurisprudence and litigation culture a bit more civilised than what we understand American? I mean, what do we know about of American litigation? We know the TV shows. I saw speaking of defamation cases, the Johnny Depp cross-examination, which I thought was just, reasonably okay, but very dramatic and very.
They disallowed evidence in that case too, and I thought there's certain things that the personal trainer and a few things, I thought those decisions were quite critical to the case, because when he sued in England, they found the truth made out, the truth made out.
That's right.
And he was unsuccessful in defamation action in English court.
But is the narrative, is the outcome, is a consequence of filming these decisions that the outcome isn't as important as the narrative that's being required? So these high profile individuals that want to make a name for themselves seemingly are playing for the camera more than the outcome. So Johnny Depp had a successful outcome, but you could see that along the trial, the social media activity was to really be quite vicious to Amber Heard in that trial, because they thought that he'd won the public sentiment. Yeah, well,
but that can go either way, can't it? Isn't there a risk when you take proceedings? That seems to me the extreme risk of what's happened, which possibly Mr. Lerman runs. But I mean, I'm sure he went in eyes open, but you're just putting yourself out there back in the public eye, and how can you know? The public sentiment it just strikes me as highly difficult to predict. But anyway,
so one of the things that I think is unique about this defamation trial, but perhaps most defamation trials do in fact do this. The evidence in chief was not by way of affidavits, and that's something we encounter a lot as barristers when we're doing civil actions. We do you usually do your evidence in chief by way of an affidavit.
Very controlled, very thought out well in advance.
A thought out well in advance story in a narrative form, prepared in a controlled environment with your solicitors, making sure that every sentence is. Good solicitors making sure that every sentence is unchallengeable. But I think in this case, there was a direction that there was going to be no affidavit evidence, and in fact, it's going to be viva voce, i.e. oral evidence. And I just think that's. I wonder what you think about that, Nick. Do you think that all cases should be oral?
I think in cases where there's in a category of case where it's not document based, it's about someone's word against another's. I think it's very important for the judge to hear in that person's own words, if they say that a certain thing was said, them to say it and to give their account of it. And also one thing that comes up with affidavits is this whole idea of how people put conversations down and speech. So they'll say, and he said words to the effect of, and the solicitor and the client, but mostly the solicitors probably sat there for hours going, how does that say? What's the best sounding version of this? We can put the version that most suits our case. And now, apparently, I mean, there's been judgments recently. I think Ian Jackman, Justice of the Federal Court.
Yes.
He has said in a judgment, interestingly, that he doesn't consider that a necessary means of it. That was the accepted standard.
One of my, can I say openly, one of my favourite judges at the moment, because he's just writing these beautiful judgments with a little bit of pizzazz and a little bit of thought and a little bit of insight and a bit more than what you'd normally see. What he did was
this is Justice Jackman.
Justice Jackman, Hugh Jackman's brother. Hugh Jackman?
Yeah,
the great actor.
Wolverine. Sorry, you made me to make it up.
No. It is funny. Kane's hire PTY Limited Anderson Aviation, he said at paragraph 119, he said this, and it's a bit of an excerpt that I won't read all of it out, but he basically said...
highlight it?
Oh, no, it's okay. The applicant expressed his evidence in direct speech, and I have extracted a number of instances of that in the reasons above. That approach may be regarded as the usual practice in New South Wales.
Accepted. Usual, even accepted.
Until about the mid-1990s, courts in New South Wales rejected evidence in chief of conversations which were not expressed in direct speech. Open brackets, although this supposed rule of evidence was never insisted upon in cross-examination. That approach failed to accommodate the fact that people routinely remember only the gist of conversations, and perhaps also particular striking or important word or phrase which was used. Is that a go at New South Wales?
Such as, what about my little mate?
Yeah, what about my little mate? So, like, if you had a conversation last week with someone and I asked you what happened, what would you say?
I can't remember.
Yeah.
Well, no, but seriously, this is the thing. This is my point. Like, you're being asked to give exactly close to word for word as something that happened often 2 and 3 years ago is when the evidence is given by the time that the affidavit evidence is prepared and filed in court.
So in a civil case where everything is dependent upon, where the outcome's dependent on who the court believes, and the dispute centred around, let's say, someone stole my car and then someone said to someone, I saw him steal it, right? So that conversation needs to be recorded word for word for it to be accepted as evidence. But usually you ask that person, what happened? They'll say to you, look, he told me he stole it. What did he say? He would have told me. No. What were the words he said to you? Now, that was a practice. Now, that's common sense. And I think His Honour, and I will use your highlighter now, he says, many witnesses must have instructed their lawyers of their memory or the substance or gist of a conversation, only to be told by the lawyer that it then had to be fashioned into direct speech.
Fashioned being the operative
by
word.
a process of construction or reconstruction, and this is the pearler.
Reconstruction.
Witnesses, mindful of the duty of candour, must have been most surprised by this practice. And how many civil cases would have resolved on the back of the acceptance of direct speech?
Yeah. Well,
lots.
Yeah, but gist is exactly how it should be. It should be the new word. What was the gist of what he said? I think it's got a lot of. I mean, it's a little bit imprecise. If someone does remember specific words,
and I think that's what they
used,
say. Yeah.
If she said this particular word, and so I therefore remember what goes around that word, I may not remember. But if there's something, it's this whole ring of truth idea, though, isn't it? It's somebody when you hear evidence in court. And someone remembers something. There's a peculiarity about something that the account they give that. Firstly, couldn't have been made up, where you think, God, and if they made it up, they must be the greatest author of fiction. Yeah. And secondly, it just has that ring of, they talk about the ring of truth. Yeah. And this is sort of the principle, is the gist. What's that thing where you just think, no, that's got authenticity about it.
And one must ask themselves, why in criminal trials do they, insist on the witnesses or the complainants giving their evidence on the spot in there, because the stakes are higher, right? And if the stakes are higher and liberty's at stake, the most reliable form of evidence comes from oral evidence. Why are we routinely stuck down in?
Well, because we need the likes of Justice Jackman to tell us, actually, no, we don't all have to do this. Let's all move on to, this is improving. This is evolution, isn't it? This is like, so anyway, another thing, Vasi, you mentioned something earlier about a special leave application or something.
Well, just speaking about high stakes litigation, here's a poor gentleman. His name is Michael Thomas Potts. He was awarded to pay.
So he was found
primary judge ordered
for
judgment for the respondent NAB against Mr. Potts in the sum of, I'm not very good with numbers. Is that 57 million? 57,278,091.
It's got 57, a comma, and then 3 digits, and then a comma, another 3 digits. So let's call it 57 for argument's sake.
Just a measly $57 million.
Vasi, can you just explain what a special leave application, or will you let me just say quickly what a special leave application is?
No,
so when one goes, if as a litigant one wishes to take one's court case to the High Court, unless I think there's a narrow category of cases which include constitutional cases and an issue where there's a case where there's a constitutional issue. But if you don't have one of those issues, you need to go to the court in the first instance and say, are you willing to hear our case, my case? So let's say you've been to the highest court in New South Wales, the New South Wales Court of Appeal. You've lost. You want to have another crack. You say you have to make an appointment. You get a hearing with the High Court
on a Friday.
And on a Friday, a couple of judges come along. It's usually two, isn't it?
Yeah.
2 judges come from Canberra, or sometimes you might have it on AVL, and you go and tell the judges the gist of the case and what the legal issue, the critical legal issue or issues are in the case, and the court says, yes, we'll hear your case. Or no, we just really don't think it's important enough, generally speaking, is the test. Is it a matter of public importance, I think is the test.
Yes, well,
and so we don't want to hear from you anymore. Go away.
And the other thing about special leave applications is that it's the last roll of the dice. You may have lost at the District Court, the Court of Appeal, or the Supreme Court, or the Federal Court, or the full Federal Court. And once you've had everyone tell you that your case is determined adversely to you, you have one more roll of the dice, and that's the secret special permission. And
if you've had a judgment for $57 million, you might be worth just having that last roll of the dice. Most people probably would.
And so what he did was he managed, and I just thought this was interesting because I don't think I've ever seen a judgment where special leave was awarded.
So they said you got through the gateway. They said you can come down Canberra. You can
come down in Canberra, bring the family. But In an unfortunate turn of events, one would think, that we are here and this $57 million judgment might be varied. We have a good chance, but in a 9-paragraph judgment, the High Court said the proper course after is for the grant of special leave to be revoked. So they heard the application, they heard the argument. They dealt with the argument and said, actually, nothing that you raised deserved the special permission.
No, we thought you did.
We thought you did.
We've changed our mind. We've heard it now.
Yeah. And, I just thought, well, that's just quite
it'd be a pretty tough pill to swallow, having gone to the High Court thinking you had a chance and then you get just punted like that. The other thing is, Vasi, I know you're fond of this and we won't spend too much time on this, but you like cricketing analogies and judgments.
I do. This is back on the Lerman trial. So there was an application by Sue Chrysanthou, senior counsel, I think roughly to cross-examine Brittany Higgins. So basically have, following Dr. Collins' cross-examination, to also have opportunity at cross-examination. The interesting ruling on that was as follows, and I think His Honour Justice Lee, and this was in the context of bifurcating cross-examination. This is a case of great... it's a good word. This is a case of great importance to those involved, and the facts in issue are serious. As I remarked during oral submissions, one is not to approach cross-examination in any case, let alone a case such as this, as though it is a social cricket match where a batsman retires at 50 to give someone else a go.
That's lovely that people are using cricket analogies, but what does he mean by that?
I think he means that there is a relevant, I like the word relevant, unfairness to a person who is being cross-examined where their credibility is in question, for them to be potted up by multiple counsel to be cross-examined on the same topics. Okay. So, for example, if we both are together running a case together, I can't have the first go, and if I didn't shake him or her up in the witness box, you can't have another go and say, look.
So it's the idea that, as in a social cricket match, that everybody gets a bat and everybody gets a bowl. That's the whole idea. Yeah. It's not professional where the good guys or girls might get a bat and a bowl. In social, everyone gets a go, and so everyone doesn't get a go at cross-examining this person. It's not like everyone gets to roll their arm over just in case they might have thought that they could have done a better job on the same topics as the person who'd already cross-examined.
That's right.
Okay, good use of analogy.
Yeah,
no, I think we should have bad and good use. Now,
well, I think if you go back to the story of time, Lord Denning was one of the fantastic writers of cricket analogies, and I think our guest might be able to comment on some cricketing analogies. He may be able to bring a couple to the table. Today we have the great privilege of welcoming former District of New South Wales Court of New South Wales Judge Stephen Walmsley of senior counsel to the show. He is truly a heavyweight and a statesman of the New South Wales legal fraternity. He was called to the bar in 1981, took silk in 1997 and was appointed a judge some 4 years later, where he remained as a full-time sitting judge up until 2013 and then an acting judge for some time after that. Stephen is the author of a leading text on professional liability,
as well as a celebrated account of the famous series of trials involving High Court Judge Lionel Murphy in the 1980s, entitled The Trials of Justice Murphy. Stephen truly puts the word learned in learned friend. Stephen, welcome to Elephant in the Courtroom. Thank you for coming along.
Thank you for inviting me, Nick.
Stephen, you hail from Yass originally, don't you?
That's correct.
You did your primary school years there, didn't you?
I had all of my primary schooling at Yass Primary School, and then I had 3 years at Yass High School, and
right.
my last 2 years were at Canberra Grammar School.
And is that why you've given a number of interviews, Stephen, particularly around about the time of the publication of your book, at least those that are accessible on the internet. You were interviewed by Justinian in 2016, and you asked about your death row dish, and you included in your death row dish lamb cutlets from Yass.
There's nothing wrong with that.
Quite right, but so why are they so good, the lamb cutlets from Yass, Stephen? What makes them?
Well, something about the water and the grass.
Is it a reminder of home as well?
Yeah.
But are they actually better? Because I love lamb cutlets myself, or is it something of just a?
I don't know.
Yeah, indeed.
I grew up on a farm on the Yass River, and I had lamb chops or roast lamb just about every day of my young life.
Indeed. When you spoke to Richard Ackland, these are some of the things you might sort of we've pulled out, but I suppose curiously you described if you were described as a foodstuff, you said you'd describe yourself as a Granny Smith apple. Do you remember that?
Yes, at the moment, it's a few years on, and I've forgotten why I chose that.
Yeah. It's my son. It's his favourite food.
It's my wife's favourite apple.
Oh, indeed. It is a great apple in itself. It's one thing I was quite curious about. So you obviously of senior counsel, Stephen Walmsley SC. Whilst one is a judge, one still always, and all the judges have SC after their name. I mean, judgeship, in my view, obviously trumps being silk in a sense. I mean, if you're looking at the ladder, why is it, do you think, that you retain the name? Is that just a title you've got and you just keep it and you?
I think as a matter of hierarchy.
Yes.
Traditionally, district court, if you become a district court judge, you retain the right to have the post nominal.
Yes.
But if you are appointed to a superior court, then it's absorbed into the commission, as it were.
Is that right? So
Supreme and federal court judges don't use the post nominal.
Indeed, I've now you mention it, I've noticed that.
Yeah. And you're entitled. I think there might be some controversy about your entitlement to, as it were, resume use of your post nominal once you retire from the bench, from the Supreme Court, from the federal court. And I don't know what the position is about district court judges, but I know that traditionally they keep the post nominal whilst they're a judge and when they retire from being a judge.
So when you were sitting back in Yass eating those lamb cutlets, by the way, where is Yass? A few 100 kilometres out from Canberra?
I'm sorry to hear you ask that question.
Yeah, I thought you'd...
Quite a well-known place. The centre of merino wool in Australia.
I'm speaking to a larger and broader audience of about 10 people watching this show, so maybe they'd want to know.
Yeah, but it's near Canberra.
Yeah, and when you were in Yass eating lamb cutlets, did you have visions of a career in the law, or how did you?
Certainly not. I thought I was going to be a school teacher.
Right.
Because that was I'd only ever met graduates who'd been school teachers.
Right.
And so it wasn't really until I left and got a bit older at school and started meeting people who had older brothers or sisters who went to university.
And where did you study?
ANU.
Right. Okay. And then did you go straight into law as a solicitor, or how did you?
Yeah. So I worked initially for a few months at the what is now the Australian Government Solicitor in Canberra. Then I worked for a few months at Sydney University as a research assistant. While I was waiting to get what was known as articles, in the olden days you had to do articles of clerkship, and I had a lot of difficulty getting articles, but eventually I got them at Allen's.
Right.
And so I started at Allen's in 1969. There were 4 article clerks starting on the same day. One of my fellow article clerks was David Marr.
Right. There you go.
Stephen, you're married to a judge,
yes.
if you don't mind me saying, and Judge Flannery.
Yes.
And in the Murphy book, you said that a judge should never express a view about what the result should be in another judge's case, even though they might talk about cases. It's improper, it's considered improper to express a view about what they think the result.
Yeah.
What's it like around particularly while there was that overlap period, I just on my reckoning of about 6 or 7 years where you were both judges of the District Court, is it? What was it like sitting around the table and talk? I mean, one assume that cases came up, did they? Of
course, we discussed our cases.
But did you ever have to bite your tongue when you sort of felt that, you had a view on the case that you thought, that's probably where that case should go, and you just had to hold back, or... Is that difficult?
I don't think the occasion ever arose, because if you've been in the law long enough, particularly if you've been at the bar, then you learn stuff about what not to say, what not to.
We're still learning that.
No, we're not. That's why this show's called Elephant in the Courtroom. No, just sorry, Stephen.
No, you just know that there are certain things that are appropriate, and there are certain things that are not. And it's no more appropriate for me to say to my wife, who happens to be a judge, I think you should do this with that case.
Yeah, right.
Than it is to say that to any other judge.
Absolutely. I thought maybe there might, if she was in a quandary about what to do, and it's very hard to have somebody to talk to, isn't it, if you're a judge? So I imagine, did you ever, I mean, this is a slight segue, but did you ever feel totally alone with a case where, because you didn't know couldn't work out where you wanted to go with it, or where you wanted to
certainly. There are times in my life as a judge when I felt totally alone. I was not a criminal lawyer when I was a barrister, but I became a criminal judge because that's all I did after a few years. And there were times when I had difficult problems with a criminal trial, and I wouldn't be able to. There'd be just times when I'd need to make a quick decision, and I wouldn't be able to find anybody to talk to about it. And my wife was obviously my normal port of call, but there are others too I would talk to on the court or not on the court.
Yes.
To try and work out what I should do.
But I suspect that's quite a common thing amongst a range of jurisdictions, that judges often will bounce ideas off people, much like barristers do when we go into the rooms and say...
It's not really all that different from... If you're in judges' chambers, you've got judges wandering in after court saying, I've got this issue, any ideas? Or if you ever come across this sort of case before...
And to be fair, some of my best points have been developed by engaging.
Most of your best points, probably.
It's been developed by talking about it.
No, we always say, we said it last time, he did go to the High Court in the first year of his first year at the bar and won, but he's done nothing since. So no, Vasi, that's what the one thing I've always found interesting and probably about is the loneliness possibly of being a judge, because it's different. The collegiality is a big thing at the bar, and it really does. It's one thing I love about the bar, that you can pretty much ring anybody at the bar within reason. I mean, obviously the open door policy on one's own floor, but you could even ring someone. I've occasionally, if I didn't have expertise on my own floor, rung somebody else on another floor.
I did that when I was at the bar. I rang senior people on other floors. Including people who were, say, the president of the bar or whatever at the time.
Those etiquettes and charms, I'm finding they're are they slowly dying off a little bit?
I fear they might be.
Because I feel early days I would call people. You'd see a case and you'd see the counsel who appeared in it, and you'd say, I don't understand what this case is about. And you'd call them and they'd happily explain it to you. But I feel like there could be some charms being lost.
Have you called someone in recent times and they've said, no, I'm not going to help you with that?
No, I just find that there's
nameless,
a bit more. I just think in the modern world we're in now, I think it's just we're losing some charms. Like, for example, one piece of tradition that I have quite loved but never had the guts to do is the old knock on the judge's door before court if you've never appeared before them and introduce yourself. I mean, I would have thought that in the early days of the bar, I was hoping that I'd be able to do that just to disarm the mystique of appearing before someone you'd never appeared before or a case. What are your thoughts on that?
I think it's very sad that it's dying out. When I was at the bar, you don't do it. You never did it really at the High Court. You had to be careful where you did it. You didn't do it in Victoria if you happened to be appearing in Victoria.
Right.
But with District Court or Supreme Court judges in New South Wales, I always went and introduced myself. if I hadn't appeared before them. That didn't mean I met them or I talked to them, but at least the message got to them through their associate that I wanted to abide by that normal tradition. And sometimes it worked a treat in helping to win the case. There was a very irascible and mad judge on the district court some years ago who I appeared in front of, and I hadn't appeared in front of him before. So I sent a message through his associate that I'd like to meet him. He sent a message back saying he was too busy to meet me. I wanted to get on with the case. I thought, that didn't seem a very good move. But when we got into court, something upset him, and it turned out that this particular judge, as some people would know who he was, he had reported a barrister for yelling at him only a few weeks before, and asked that he be dealt with for contempt. And the Court of Appeal considered the matter and decided that it was not contempt to yell at a judge. That case is often given to readers at the bar readers course to look at. Anyway, the judge, who was too busy to talk to me, got chatting and said, "Look, I should say that Mr. Walmsley very, very properly asked if he could meet me before we started the case, in line with all the traditions of the bar, which are sadly dying now, because only last week the Court of Appeal said that it's all right for a barrister to yell at a judge."
Well, have the contempt standards, have they improved? Are they being raised or lowered in more recent times?
I don't think contempt is. No, the conduct. If you look at some of the old contempt cases involving barristers, there's one involving Tony Blanto's father back in the 70s, I think. And there are lots of them around. I think there was one of Ogden in Victoria, where he talked about the judge being like a referee who put on the jacket for one side instead of the other side.
Because I couldn't help detect that one man known as DJ Trump in the United States is freely remarking about his court appearances, the trial judges, his family.
I was thinking of lawyers who get involved in
but it just occurred to me that in itself might well be something that...
A form of contempt.
And I'm surprised
to be a different set of rules.
So it's a different set of rules, different set of world and others.
So, Stephen, you obviously had a number of barristers appear before you.
Yeah.
What makes I'm interested in what makes, and I think a lot of barristers, if any of them care to watch this, would be interested in what you think makes a good cross-examiner. And while you think about that, or you may not need to think about it, I wanted to read a quote I very much enjoyed from your book regarding Alec Shand. And Mr. Shand was considered he was an eminent barrister of his time, and obviously he was involved. He was Justice Murphy's counsel during the first trial, wasn't he? And you said of Shand at page 123, Shand was an experienced barrister, but his technique was not to everyone's taste. He would adopt a sneering tone, be extremely firm, at times loud, and often repetitive. He had a reputation for being an effective cross-examiner who did not include subtlety in his weaponry. Am I to take it, and you may not wish to, that you obviously prefer cross-examiners who are more subtle and less loud?
Yeah, I think in general terms, judges hate loud barristers.
Yeah.
The fire and brimstone types. The best ones, the ones that judges enjoy listening to, are the ones who are quietly spoken, not verbose, of course on top of their subject.
Yes. Not
rude to the witness. I cannot abide a barrister being rude to a witness, no matter how big a liar they've shown the witness to be. There's no need for it.
Right.
You've made your point, move on.
And is that standard, that's a judge's standard and a view that I totally echo and believe is right, but is there a different standard or approach necessary for a jury trial?
I don't think so. I think juries shudder just as much as judges do when they hear barristers being rude to witnesses. They get the idea from watching American television shows that rudeness and yelling
or as we were talking earlier, actually American trials that are consistently filmed or published.
But it's also, I've always thought, if you're trying to get something from somebody, which is one of the things you're trying to do in cross-examination, I think you point that out elsewhere in the book, you're either trying to get admissible evidence or you're trying to perhaps discredit the witness if you can. If you want to get something from them, you don't want to upset them and be rude to them because someone's less likely to give you something that you want.
I often use the Aesop fable about that. I think it was Aesop wrote a story about the contest between the wind and the sun, and they each had a contest. They had a contest to see who could pull somebody's cloak off.
Yes, and
the wind, buffeted and blew and was loud and went on forever. But the more it did that, the more the person held the cloak tightly to himself.
Yes.
The sun just started very softly, few rays, increased them a little bit, gently, and eventually the person just took his own coat.
I think that's fantastic. I love it.
Beautiful.
So when talking of being in, I suppose, situations where you need to make a decision, you've either got to make it quickly or even if you need to make it slowly, we were wondering about sentencing. Would you say that was one of the more difficult aspects of your role as a judge?
It is difficult, yes. It's been made difficult by politics, unfortunately, because politicians have been affected by what newspaper headlines have said about them when they've been criticised, and so they've said to their Attorney General, "Oh, you better put something in the statute about that, in the Sentencing Act." And so over the years, since 1999, when I think the Crime Sentencing Procedure Act was passed, the Act has got more and more and more stuff put into it about things that judges have always taken into account. But just in case these people who've got law degrees and been at the bar forever forget, then, they put in the Act. And what it's done is it's provided a lot of scope then for them to leave things off. If there's something in the statute that says you've got to consider it, no matter apparently how minor, and you've forgotten about it or it slips past you, then there's an appeal point.
Exactly.
So you worry about that sort of thing when you sentence somebody. And if you look at the CCA reports on successful appeals, well, most of them are not successful, but some of them have been successful because people have just forgotten something minor.
Well, I wanted to talk to you about the appellate process in a moment, but just going back to sentencing, and you said it's more challenging by reason of the statute. That's because it's more legally complex and convoluted.
It is, and it gets more complex every year. And of course, we've got two regimes, Commonwealth and State.
But what about, because we've detected, and I've known you for a little bit of time now, I detected a real humanity to you, and dare I say, even a kind and empathetic heart. Did you find the sentencing process difficult from that perspective at times?
No, I don't think so.
Right.
Do you think you were considered, if you took time to think about it or care, but a tough or lenient judge on a scale of that, or you always just did what you thought was right and that was just, or was there
I think I always tried to work out what was the appropriate sentence. I mean, there's a range of sentences always.
Yes.
And I would tend, these are the sorts of things that go through your head. I'm not sure that I've got the range right, but if having determined on a range, I might, I can see that the Crown is going in very heavily here. sort of case where there might be a bit of public flack for the Attorney General or for the DPP if I'm a bit light.
Yes.
We've got to take that into account because that means that there's more likely to be an appeal
Yes.
by the DPP. Not that they succeed in a lot of their appeals, but they succeed in more appeals than they probably should. And so you take that into account because if you're concerned about the accused or the offender, because you just feel for them.
Because you like them or you feel sympathy
Like them.
towards them. That's what I mean.
That's what we're getting at.
Like cases, things like that. You don't want to give the DPP an appeal point. So sometimes you might have to be a little bit higher than you would otherwise. Than you'd prefer, to make sure that no one can say, "Oh, it wasn't."
Because then they might get even more on appeal.
That's right. And
exactly.
Because in the course of
I probably you'll regret me, or you think I'm going back to this Ackland interview, but it was a sort of it was a fun interview in the sense that we got to know, well, the reader gets to know you a little bit personally. He asked you to describe 3 traits of yours, and one of them was irritability, none of which you've shown today already, having putting up with us.
Well, I haven't been here long enough yet.
No. Did you feel that you'd ever been, if you had been on one of your irritable days, or and we all have them, been irritated by a barrister in court one day and you were a little too hard on them? Do you ever feel?
I have felt that way.
Because these days judicially bullying's become a bit of a live issue, and other judges
as it should be
spoken about. And when you've said you did that, obviously we don't probably need to go into, we wouldn't be willing to go into specifics about that. But did you, if it was in a trial or something, did you sort of reflect on it overnight and think, oh, maybe I could make it up to the barrister the next day by being a little bit easier on them, not in terms of giving them any favours in the actual case.
No, there's no doubt that happens. Somebody irritates you, and you might overreact, and then the next day you might be overkind to them.
Yes. Never an apology. Just
don't apologise.
You don't know exactly.
Just suck up to them a bit.
Yeah. Well, just a little more differential.
We're all familiar with that, aren't we?
So what are the most annoying things did you find advocates did? We sort of touched on that a little bit with cross-examination about being loud, but is there anything particularly where you just said, oh, that's my pet hate?
I hate people who say good morning.
The good morning.
Because I haven't read that judgment of George Palmer.
Yeah. I was in his year, and that was
when he gave that judgment. It was a wonderful judgment. Yeah. Every barrister should read it and cringe, and if on realising that he or she has offended. I can't stand barristers who talk over the top of me. It's unbelievable but it does happen. Barristers interrupt judges when the judge is talking. In the olden days, you were taught if the judge is speaking, you shut up, because not only is it impolite, of course, to interrupt, but that's how you really know what the judge is thinking about the case and how it might help you to win it.
Just on that good morning case, that case was involving the intervention of community services, where the facts are slightly distant from a memory, but the counsel representing the department was running a case that the mother of this child, it was in the protective jurisdiction, was unfit to have restored contact. And the cross-examination went for 3 or 4 days from memory, and every session started with a good morning, good afternoon, a personal exchange, and then the familiarity that created, juxtaposed with the ruthless sort of attack that followed, just didn't sit well.
Excuse me. So there was a good morning between the judge and the advocate?
The good morning. It was not only just a good morning to the judge, but it was a good morning to the witness in the cross-examination.
And the judge made specific comment upon that in the judgment, and how inappropriate the judge thought that was.
But this is coming from one of my favourite inspirational people of the law, just someone who's got the greatest command of humanity and dignity that you could have, I think, in the law. So it's big judgment from him, and I'm sure that everyone's learning from it.
There's another issue that irritates.
Yes,
I should mention it.
Most definitely.
A lot of barristers and solicitors, when they're referring to a judgment of another judge of the same court, will say, this is, I'd like to draw your Honour's attention to this decision of Your Honour's brother or Your Honour's sister, so-and-so. And that's one of the few things that irritated me more than that, because it's quite presumptuous to describe somebody as somebody's brother or sister. It's done, but I think it's quite presumptuous. And you don't know what that judge who you're appearing in front of thinks of the person.
That's right.
And for all you know, that judge thinks that the judge who wrote that judgment is a complete idiot.
Yeah.
And there's no doubt that on some courts, some judges have very low opinions, some of their fellow judges.
Yeah, I've seen that.
It's very dangerous. Very dangerous talking about.
I should hope, Your Honour, that nobody ever said this is a judgment from Your Honour's wife or partner.
I don't think that ever happened.
My word, I'm not sure if that would have been.
You would have to follow it.
But I just mentioned that I practiced for many years in the ACT, and I thought there was a lot of good sense when, at one stage in the 1980s, the then Chief Justice, Richard Blackburn, issued a practice direction saying that in future it would be not regarded as appropriate conduct for a barrister in describing a judgment of another judge to talk about that other judge being Your Honour's brother or sister.
Yeah, absolutely.
On the basis that it's a matter for the judges to say whether they regard these people as their brothers or sisters, not the bar.
Well, no, but just for it's the same principle as the good morning idea, isn't it?
Sense.
It's the idea that there's an independence there, and it needs to be observed in all facets of court conduct and behaviour. Stephen, you were involved in some interesting cases, and again, these are things that I've heard about elsewhere, and you've talked about them in some detail elsewhere, but it just sounds like a fascinating case, the Noah's Ark case.
Yes, it was.
So in that case, you were for two applicants, were you not?
Yes.
Who were suing a man who was going around professing that given that there had been a purported discovery of the remains of Noah's Ark in Turkey somewhere, he was that proved certain parts of the Bible, including well-known parts of the Book of Genesis. And your two applicants sued for one was a professor. He was sued for misleading, deceptive conduct, and the other one sued for breach of copyright. That was Mr. Fasold. He'd written a book, hadn't he?
Mr. Fasold was an American who had written a book, including a map that he had drawn, which was his original work, and that had been taken by the man who he sued in Sydney. Did you
need to do a review over there in Turkey? Was there any sort of
no, but my solicitor, my instructing solicitor, I think had a trip to America where he took a number of statements from people. I was very jealous.
I imagine so. It was so extraordinary. Sort of apparently the evidence was voluminous, and it was some case in scope and volume, and ultimately ended up in a result where, against the professor, that his case was unsuccessful, his cause of action.
Professor Plummer, yes.
Professor Plummer, and the Fasold, Mr. Fasold's case was successful for breach of copyright with damages of $2,500.
Nothing wrong with that.
Nothing at all. A win's a win, as they say. I mean, and then there were costs. My word, I just dread to think. But a great case. Another one of us brought this to my attention. Because you practice in family law, you might want to raise this, discuss this case with His Honour. And this was AA and Register of Births and Deaths and Marriages, a 216 case.
You spent time in Canberra as a judge, acting judge in Canberra.
I was an acting judge in Canberra. But I don't think I don't think that
AA
was
was sitting
case.
here. You were sitting
That was
in
a district
Sydney.
court case.
Well, I just saw AA because it was my initials. I thought that was maybe a case about my historical child adoption process.
Oh, golly.
No. I think this is where I got the idea that maybe there would be a degree of humanity, which I know there is, but in how you approach litigants that came before you as a judge, and that was this decision where a female de facto sought to remove the biological IVF father from the register.
Birth testimony.
I remember the case.
And you had, you were faithful to the statute that said that, look, by reason of X, Y, Z, you must be removed. But you expressed a great deal of sympathy for what would no doubt be a significant, substantial grievance to the biological father. And I just thought that was a great example of you showing some dignity to a litigant, especially in the judgment.
Very kind of you to say so. I think he represented himself.
He represented himself, but there was an irrebuttable presumption, as I recall, in the relevant statute, that if a child had been conceived via a fertility process, that the biological father who was involved in the fertility process was not treated as the presumed parent.
Yeah.
And so you were sort of bound, it seemed, by that statute, because the interpretation of it left no room for a decision either way. But part in the judgment, you've said, you said, I have considerable sympathy for BB, the father. He'd done what he considers the very best for his child. He made financial commitments to AC and AB, who were the two female de facto, one was the biological one, the other was de facto parents of the child. And he and AB was the child, AC and AB weren't the de factos, AB was the child. He had a strong emotional attachment. He was older, he was 58 years old. I mean, very, very, very difficult decision, I imagine, for you, where you felt, gosh, what might feel like the right decision is the decision I can't make here.
I know. I was troubled by that. Nothing I could do, of course.
Did you ever feel were you ever in circumstances, we're talking about stretching the law, where you could and did afterwards feel like you pushed the law a little bit outside the realms, because you might have been in common law territory or something, and thought, well, this could be appellable, but I really I really feel that the right result is X, so I'm going to do that. And then afterwards thought, I wonder if I'm going to be appealed or were appealed and then upheld or overturned. Did you ever have any cases like that where you strived?
I don't think so, because the thing about judges is, like anybody, you don't like to be wrong or to be seen to be wrong, particularly publicly wrong. When the CCA or Court of Appeal decision comes. So you don't do anything like that.
There's a professional pride that sits above the top.
It's
duty, actually, probably.
Duty, pride.
Yeah, that's
quite right. Speaking of getting things sometimes wrong, do you you would have sat on numerous jury trials and presided over them. Do you have any thoughts you want to share with us about what you think of the efficacy of juries versus judge alone trials, and also in that, can you touch on whether you had any experiences of going, the jury got that wrong compared to what I thought at all?
First of all, I think in the whole of the time I was a judge and an acting judge, over 20 years, I never had one case where a jury found somebody guilty where I disagreed.
Right.
On the other hand, there were cases where juries found people not guilty, where I, as a judge alone, might have convicted.
Right.
But it's difficult because when you've got to judge a jury trial, of course, you're not concentrating in the same way as you are when it's a judge alone trial.
Right. That's so interesting, because I would have hypothesized that a jury is more susceptible to being inflamed or having more like,
persuaded by
emotions. Whereas often one would think that this is the kind of trial which we can win on on a very narrow, constrained, judicious mind analysing the evidence, as opposed to a jury who's a bit more of might be more touchy and feely. But you've said that you actually thought that they were more lenient than maybe you were.
I think they were when it came to
just
finding people not guilty.
On your impression.
I had one case where I disagreed with the jury's verdict of guilty, and then when it came to the sentence, the offender conceded that he was guilty.
Wow.
And that concession would have helped his remorse, I suppose,
it did.
for his mitigating sentence.
Out in record
time. Nick, my first encounter with Judge Walmsley, as I used to call him then, or Stephen, it was in Burke, I believe it.
Weren't we lucky to be in Burke?
Yeah, and I recall running one of my criminal trials out there, and there were about 14 or so witnesses that my client was accused of holding up a service station with a knife. And there were about 14 Crown witnesses, all from the service station,
Yes.
So and so. And I said to my client, I said, mate, like, it's going to be tough work to knock all these witnesses out. I mean, they all saw you there.
So
you did it.
They identified.
They identify you.
Yeah.
I managed to run a successful argument before him about his honour about a recorded interview, and we knocked that out.
You still had these problems.
So I just noticed a question here, Nick, which you haven't asked yet. Who was the most impressive advocate that appeared before you? And why?
I was hoping that was going somewhere, but I wasn't expecting it was going there. There's always, he's trying to use this, but it might seem, but he's not trying to use this as a self sort of promotion exercise. But
okay, let me go. So we did well at that, but then we called the first witness, and it was him. Second witness, no, definitely him. Third, and we got to the fourth, and about 10 to go. And I just said to him, mate, like, at one point I was cross-examining the witnesses on whether the curtains were sheer inside the service station or whether they were printed. And in the end,
did you have your glasses on?
Well, once we had the fifth witness that sunk him, I just said, I think we've got a shot here with this judge. Let's get whatever utilitarian discount we can for the next couple of days, and we pleaded halfway through the trial.
You don't have to express this view, Stephen, but perhaps you consider that a wise decision.
It was a very wise decision.
One of the very interesting parts of this book, and it appears a very much as everything in here has to be, a very deliberate choice on your part, Stephen, was that. And I just found this fascinating that so John Laws is there on radio talking about the Murphy
It can't happen
trial.
now, but
it can't happen. And the head juror, the four-person or four-man, now we would four-person, four-man, rang up. He must have stopped. I mean, this is in the 1980s. He must have stopped his car and jumped into a phone booth because this happened on live radio, didn't it? And sought to and did quite eloquently and effectively defend himself and the jury's decision. I found him extraordinarily sort of persuasive and impressive. And it served to sort of reinforce something that you've already said about one's faith in and how the public should have great faith in the jury system and how important it is that we have juries and that they get it right. And
I think they certainly do.
And it was interesting in the Murphy case that the juror said, this four-person said, look, we didn't necessarily agree with the way it was, that the charge sort of locked us into a position we didn't really like and we didn't even think it was really fair, but we felt bound by the way the law was about this particular charge. Yeah. And isn't that excellent to show that it's not about, they're not operating on at least there in such a critical trial as that, not operating on emotion. They're getting it. They're understanding the law and the nuances and they're getting it right. So it should give.
So, here's one for you then, Judge, or Stephen. And just on that How was it like to be called judge your whole life outside of being court? Did it make you more virtuous at all times?
I doubt it. I doubt it. I mean, it was really just a matter of distinguishing who were the judges and who weren't the judges.
But you go to the news, you go to the cafe on the weekend, and you're not a judge there, but someone's calling you judge. You're all of a sudden having to sit up properly and behave yourself in all respects at all times.
Yeah, one of those things you had to put up with.
Sure. Okay.
Didn't seem bound by that. Seemed as if you felt bound by that, though, Stephen, in your day-to-day affairs.
No, I don't think so.
One acts is one acts.
Yeah,
one does. But on that jury system, do you have a view about an accused's right of silence and not giving evidence? The decision to give evidence and not to give evidence. We as lawyers and judges are trained to accept that right as sacrosanct, and that one shouldn't be at all disadvantaged by the failing to give evidence because the burden rests fundamentally with the prosecution.
Yeah.
How do you think that juries respond to that question, especially in cases where it's sort of very hard to work it out?
Well, I think that these days juries. When I say these days, I say the year 2023, as opposed to perhaps what went on in the 70s and 80s.
Mm-hmm.
The judge, if there's no evidence from the accused, the judge is required to tell the jury that wasn't obliged to, didn't accept any, wasn't obliged to speak, and they shouldn't draw any inference adverse to the accused, etc. And then when they do give evidence, there's the other direction, saying that wasn't obliged to, etc. I think in a case where somebody doesn't give evidence, the jury's properly informed by the judge as to
so you didn't detect
what to make of it.
Yeah.
I don't think I ever. There might have been one question from a jury in all my years saying, is the accused giving evidence or something like that?
That's a jury note that came to you.
Jury note, yeah.
What's the funniest jury note that you can remember? Can you remember any that you can share?
I can remember one. I'm not sure that I should tell you, but I had one.
Well, we can always cut it out later. But you can tell us if you like.
I had a case where the jury panel turned up, and one of the members of the jury panel had a ukulele with him. Anyway, I didn't think too much of it. The case went on for a couple of weeks. It was a drug importation case, and the accused, who I thought, against whom the evidence I thought was extremely powerful, the accused was acquitted. And afterwards, one of the sheriff's officers brought me a note which he or she had found in the jury room, just in case I needed to do anything about it. And it was a song that had been written, and I assume, perhaps incorrectly, by the man with the ukulele.
Mm-hmm.
The whole of the case had been set to music. He'd written the words, boring prosecutor, boring defence counsel, boring judge, He talked about everybody in the case.
Oh, wow.
He'd done a little song.
He'd made a little...
No doubt sang it in the jury room.
Yeah. Well, this is... Now, this is a case that wasn't named, but I just have to ask about this one. Justice Katzman, well, speaking as she was then senior counsel on behalf of the bar at your swearing in, referred to another case, a medical negligence case. Well, there was a causation issue. A man who sued for a hip injury, and he was convinced that his punishment was that the hip injury was a punishment for his perverse sexual practice, said to include a menage a trois with his wife and his dog. Do you remember that case?
I do.
How on earth was that particular fact relevant in the case?
He felt. I didn't run the trial.
Everyone needs a laugh.
I was briefed only on the appeal. I think Dennis Wheelahan ran the trial.
Right.
And wasn't available for the appeal. My recollection is that in the course of either having treatment or being seen for medico-legal purposes, the plaintiff saw a psychologist and told the psychologist about what was going on at home.
Right.
And then I think that the judge, I think the insurer took a view on causation, which didn't help.
Well, this is what I was going. The only way I could conceive of it having any relevance is that it had some role in the causation of injury. If he was doing those things at home, could he have suffered the injury other than the way he says it occurred in the accident, or what was the causal role?
I think it was said to be part of the sequelae of the accident, and
right.
that he had this unfortunate psychological reaction.
And so it had caused him to, but the accident had caused him to behave that way.
No, he always behaved like that, I think. It was just that he felt bad about it.
Oh, indeed. Poor bloke. We've been talking a little bit about the Higgins-Lerman trial. I mean, have you been following that at all, Stephen, in terms of the telecast?
I watched a little bit of the plaintiffs or the applicants' evidence. And I might have watched 3 minutes of the Higgins evidence.
What do you think of this of the telecasting, effectively, of the?
I think it's
evidence?
A really, really good idea.
Interesting. And why do you think that?
Well, I think it helps members of the public understand the legal system and how judges work and how witnesses work. You watch Justice Lee, the way he deals with witnesses and counsel, and
very well and
very
balanced and fairly,
professionally and politely and with humour from time to time. And I think it gives people a very positive view of the law.
Avas and I were watching a little bit this morning, and Dominique Hogan Doran SC was making an application, as I recall.
So she was. We caught a nip of it, so I'm not sure we fully understand the context of it. But the application was to the effect of ensuring that someone whose interests she represents, i.e. a witness, perhaps not give evidence by way of live stream because of the added pressure that puts on her to give evidence by reason of, say, 25 to 30,000 people watching the live stream. And I think his Honour Justice Lee was quick to point out that, look, he's hoping to consider any aspect of this, including medical evidence.
Of course.
That was, I guess, what the flip side to the what you've quite obviously validly said, that about having the public understand how the administration of justice is. Does it also adversely affect the administration of justice, because witnesses who, particularly lay witnesses, we all know as a barrister or what have you, the pressures of being in court make it difficult sometimes to just put to do well and to do your best job. For a witness it's an unfamiliar territory, going in and having to give evidence, knowing that there's also thousands of people watching you down a line, probably making comment live through social media about what they think of you and what you're saying and the substance of your evidence, perhaps. That may well adversely affect a witness. Would you accept that? Would you?
Of course.
And that puts a certain pressure on the administration of justice, which is certainly a downside, I think, to it.
Well, yes, and that's exactly the sort of case where somebody on their behalf might say to the judge, does this really have to go out on live stream?
But what does and what doesn't? Just because a witness, that's the difficult thing, isn't it? You find yourself that once it's out there, and what's good is good for the goose and what's for the gander, sort of thing. Where what does decide? It's a difficult line to draw, isn't it?
I know, it's troubling. I mean, when you receive a subpoena, it means a bit more than it did before live streaming.
Absolutely. I mean, they don't there's no live streaming of criminal trials here, is there yet?
Not that I'm aware of.
No. What would you view if there'd been an application, if there was a question about yay or nay on it, would you have?
I don't think it would be appropriate, really. I think that the opportunities for people to say inappropriate things online about the accused or about the jury or about something else, which might then come to the attention of the jury.
Well, this is it.
I don't know.
Jury trials.
I'm troubled by it.
But I suppose that's the question. Like, where do you draw the lines to the access to justice? And some defamation trials I think used to be judged by jury, or they could be judged by jury.
Yeah,
I know this one isn't, but I know that there is a practice of it.
In New South Wales, there are aspects of the jury of the defamation case that's by jury.
So perhaps that's the line.
And I guess the concern I was raising earlier to Nick was that at times you wonder if the proceedings by high-profile individuals with the resources to fund it are using the trial as the very vehicle for some other collateral profile purpose, and it becomes a bit of a distraction.
Well, that's always been the case with civil cases.
Right. Do you think similarly? I got the sense that the Noah's Ark case was a case fought as much for a cause as anything else.
Yes. Well, those who backed my clients were the I've forgotten their name. Oh yes, they were the Australian skeptics.
Yes, that's right. I remember that. Yeah. And see, litigation seems to be a bit cause-based in the way it gets back to now. Perhaps the Ben Robert Smith trial. It would appear that there was a backup for Ben Robert Smith. Was there a media element? There's a media titan element or media organisation. I mean, it seems that. Do you think litigation for causes is ill-advised?
Well, it can be. Look at Oscar Wilde.
What did? Could you refresh me, Oscar Wilde? What did he?
He did what Smith did. He sued for libel. Well, no, it hasn't happened. It hasn't happened to Smith. I withdraw that. But he sued for libel. Somebody left a note at his club and accused him of being a sodomite, and he sued the author. And it was proved while he was giving his evidence that in fact he was a sodomite. He was then charged with sodomy, and he went to jail.
Convicted and went to
several
jail.
years.
Yeah.
Well, it's happened to Smith since he's been convicted.
So
he's lost.
He hasn't been charged.
But he hasn't been tried on the charges.
He hasn't been tried.
No.
Right,
so
okay.
if and when that happens, it may. But
I don't think he's even been charged.
No, of course not.
Yeah. No. But it's again. That's part of the risks of doing these things.
I have one more question to bring back to, because I think would be a nice way to finish off. So
were you really the best barrister?
I'm really the best barrister. No, I was just wanting to know, well, what now for you? We'd like to know, so you've written a book. Is there any more books in the pipeline?
Yes, at the moment I've probably written about 90% of the first draft of what I hope will be published as a biography of the late Ian Barker.
A great advocate.
Who was, of course, I think, probably one of the finest, not the finest jury advocate of our time.
That was a question I was going to ask you, so I'm glad.
And he of course, was the prosecutor in Lindy Chamberlain, which made him famous. In Australia, he was well known in the Northern Territory before that, and he was well known in his circle in Sydney, but he'd only been in Sydney for a couple of years at that stage.
And when can we expect the release of that book?
I hope that I will finish it in the next 2 or 3 months.
Excellent.
I hope it'll be published next year, if I can find a publisher, that is.
If
I can't, I'll publish it myself.
All right.
Well, we'll have to look out for that. So, Stephen, as we can call you now, thank you for coming onto the show and agreeing to be here. It's been some time since I sat on a plane next to you in absolute awe after the trial from Burke. And we've managed to have some really nice conversations over the past 10 years, and you've been more than you'd know, a little source of inspiration for me at the bar around things that we do. So we're very happy to have you on the show, and Nick, it's been wonderful to have you.
Thank you, sir.
Thank you both.
Good.
For inviting me.
Thank you. So that's all we've got today. When I say that's all, that's an understatement. It probably shouldn't be made, but it was a great show. Fantastic to have Stephen on. And of us, congratulations on your the birth of your new baby.
Thank you.
And thanks for joining us.
Thank you.
Next time, we speak with the boxing butterfly Margaret Canoon SC about her 4 decades of criminal trial work and why she used to keep a martial arts weapon in the pocket of her bar jacket.